I'm Carol Lawson, an estate planning and probate attorney in Clearwater, Florida. Today we're going to discuss living trusts. Most people need a living trust or a revocable trust, as they're called. One of the main purposes of a living trust is to avoid probate. Probate can take a long time, meaning your heirs won't have access to their inheritance until that process is completed. It can also be very expensive, eating away at the amount that your beneficiaries would inherit. A living trust is one tool that we can use to avoid probate for the assets held by the trust. We recommend you put all your personal property and valuables in your living trust, but not your real estate or your vehicle. We want real estate in a land trust or some other entity, not a living trust. The things that you put in a living trust are going to be bank accounts, investment accounts, personal property. Your living trust should be the beneficiary on your life insurance policies, your investment accounts, and any sort of land trust, and any items of personal property that you have passed down the family for years or generations. A living trust is not going to protect you from liability, which is the main reason why we don't put real estate into a living trust. Living trusts should have all of your personal property when you form them assigned to the living trust. I also recommend that you have a will as well, specifically a pour over will to capture anything that was not added into your living trust. But ideally, everything is in your living trust. This trust allows you to name who you want to inherit your things upon your death, and so you're not leaving it up to the state to determine who gets your property. You're also not opening it up to the probate process to where family members can fight over who's entitled to what, and by avoiding the probate process and the expenses and time associated with that, you're keeping your personal wishes private and the way you want.